Welcome to the legal side of packaging, where we break down the big legal questions and updates in the world of packaging. Hosted by me, Eric Greenberg, an attorney who drives his wife crazy as I read labels when we're just trying to get through the grocery store. And on the subject of food labels, today we're going to talk about accuracy. Accuracy is essential. Imagine this unfortunate yet all too real scenario. You get something wrong on your product's food label. For example, you get the ingredient list wrong somehow, or you have the details in the nutrition facts box wrong, or you have a typo in your address. And the question is, so what? Well, on the one hand, the legal definition of a food that's, quote, misbranded, end quote, and therefore unlawful, includes pretty much any error you can imagine, big or small, important or trivial. On the other hand, there's many situations in which label errors result in little or no regulatory trouble with the Food and Drug Administration, the FDA, provided you correct them reasonably quickly. Do all errors warrant a recall? No. Probably the biggest factors to think of are whether the error ends up misleading the public about something important or whether the error leads to a potential safety issue. Safety issue like what? Well, like most notably, if you fail to disclose the presence in a food of a major allergen, that's what. The major allergens that must be disclosed on food labels in the US are milk, eggs, fish, shellfish, tree nuts, peanuts, wheat, soybeans, and recently added sesame. Failure to disclose any of those can lead to serious health problems for allergic people and warrants swift and thorough remedial action. And remember, the list of allergens that need to be disclosed is a little different in every country. The list I just read you is the list for the United States. More generally, when it comes to label errors not involving safety issues, it's pretty common that FDA would react by issuing what's called a warning letter to the company involved, noting the alleged violation, asking the company to correct it. If they do, that's often the end of the FDA consequences. Now, warning letters are public, though, and are embarrassing, so it's a good idea to work to avoid getting one for that reason alone. So how do you stay on the legal side? By being careful, of course, and getting help when you need it. In my view, everyone in the chain of commerce should take these issues seriously. That goes for the brand food company, the distributor they buy from, or sell to, a contract manufacturer or packager if they use one, and the suppliers of all the component ingredients and materials. That's because the law lists a whole range of prohibited activities related to misbranded foods. The misbranding of food, the movement of misbranded food in interstate commerce, the causing of the misbranding of food, and so on and so forth. Pretty much any company with a role in a misbranded food getting into commerce potentially has FDA liability. Also, there's a different kind of hazard to be alert to. More and more statements on food labels, and not only mistakes, are the subject of lawsuits on behalf of consumers, what we call class action lawsuits that allege that something about a label is false or misleading and misleads the consumers who saw the label and bought the product. Claims like a food saying that it's, quote, natural, end quote, are a common target of this type. Sometimes the plaintiffs can claim you misled consumers even if your label complies with federal requirements. These cases are more than embarrassing. They often end up being costly litigation, and even though they're most often settled, even that costs money too. The risks of these cases is impossible to eliminate completely, but it can lead many companies to be more conservative about the label claims they make for their foods. Thanks for watching, and subscribe to stay on the legal side of packaging. And remember, it hurts my feelings when you don't watch these videos, but don't worry, I have no way to tell.